If you've inherited farmland with siblings or relatives, you might find yourself in a unique kind of ownership situation, one that raises a lot of questions. My name is Jason Smith, and I'm a licensed land broker and farmland auctioneer at DreamDirt. As a licensed real estate broker, I help families every day navigate the process of selling farmland and dealing with inheritance issues. Two of the most common structures we see are undivided interest and corporate ownership. And in this video, I'll help you understand what those mean, what you actually own, and how you can go about selling your share. Let's start with undivided interest. If you inherit farmland along with others, like your siblings, you might each receive a percentage of interest in the whole property. That's called an undivided interest. It means that you own a portion of the entire property, not a specific portion of the land. You have equal rights to access and use regardless of your percentage. You can sell your share even if the other owners don't want to sell theirs, but that can get kind of complicated. Under Iowa law, and surrounding states have very similar laws, any co-owner has the right to petition for partition, which means forcing a legal division of the land or a sale. Partitions can be done in two ways. Partition in kind is dividing the land physically, which is rarely feasible for farmland, or two, partition by sale. The court orders the entire farm to be sold and the proceeds to be divided. Any sibling that didn't want to sell will get the opportunity to fairly compete for the property and could buy the property in that forced public sale. This ensures that you get the full benefit of your inheritance and they still get the opportunity to keep the farm. Selling your undivided interest privately may be difficult since buyers usually want full control, not a shared interest, and co-owners may be your best and most suitable buyers in that situation. But there are strategies and legal pathways to help you exit fairly, and we can help guide you through that. Now let's talk about corporate ownership. Sometimes a family creates a corporation or an LLC to hold farmland. Each family member owns shares or units rather than direct title to the land. In this structure, you don't own the land directly. You own shares in the entity that owns the land. You're typically governed by a corporate agreement or bylaws which lay out the rules for selling, transferring, or voting and land-related decisions. Some agreements restrict the sale of shares to outsiders and require other shareholders to have the first opportunity to buy them. This setup can help preserve family ownership in the family farm, but it can also make it harder to sell the interest if you want out. If you're in a situation, the first step is to review your operating agreement. That will tell you your rights, your obligations, and the options for exiting from the corporation. So what can you do? Whether you're owning an undivided interest or corporate shares, you may be wondering, what's my share worth? Can I sell it? Do I need permission to sell it? How can we avoid a family conflict? Because nobody wants that. These are all common and valid questions. At DreamDirt, we specialize in helping families navigate these exact situations. We work with attorneys, accountants, and title professionals to help you understand your rights and achieve a fair outcome without any unnecessary conflict. Whether you want to sell your interest, buy out others, or just understand what you own, we're here to help you. Reach out to DreamDirt for a free confidential conversation and consultation. Let's explore your options and help you make the right decisions for your land and for your family.